Hello and welcome, everybody. It's my great pleasure tonight to welcome you here to the inaugural lecture of our Radzinovich Fellow, Sir Max Hill. I just wanted to say at the beginning that I'm very delighted to see so many of our faculty, so many students, many members of the law faculty here. But I also wanted to especially emphasize that I'm delighted that we have quite a number of alumni who have come here especially for that event. And that's quite a special thing for us to happen and to see those of you who've been studying with us previously back here with us. My name is Manuel Eisner. I'm the Wolfson Professor of Criminology and currently the Director of the Institute. The Sir Leon Radzinovich Visiting Fellowship was established by Sir Leon Radzinovich in his testament. He was the first Wolfson Professor of Criminology at Cambridge and the founder of the Institute in 1959. More than any other person, he was responsible for the establishment of criminology as an academic subject in the United Kingdom. Cambridge was the first British university to establish an interdisciplinary institute of criminology, and Radzinovich successfully led the institute through its first vital decades. Holders of the Radzinovich Fellowship are persons who have served with distinction in government, the judiciary, parliament, or other public office in the United Kingdom or elsewhere. The establishment of the fellowship reflects Sir Leon Radzinovich's conviction that as academics, we need to maintain conversation, engagement with policy and practice throughout. I'm therefore really delighted that Sir Max Hill has accepted our invitation to become the 8th Sir Leon Radzinovich Visiting Fellow. Max has more than 3 decades of experience in defending and prosecuting some of the most complex financial crimes, high-value fraud and criminal cases to arise out of the UK, covering issues such as cartel investigations, corruption, corporate criminal liability, and terrorism funding. He has held a number of prominent positions, including serving as the UK Independent Reviewer of Terrorism Legislation, leader of the South Eastern Circuit, Chairman of the Criminal Bar Association, and Chairman of the Kalischer Trust. From 2018 to late 2023, Max served as the UK Director of Public Prosecution, the most senior non-political public prosecutor in England and Wales, after the Attorney General and Solicitor General. Max was appointed to the then Queen's Counsel, now King's Counsel, of course, in 2008, and in January 2024, he received the knighthood and was appointed a Knight Commander of the Order of Bath in the New Year's Honours List for his services for law and order. During his term as a Radzinovich Fellow, Sir Max will strongly support the Institute's dedication to rigorous research on an evidence-based crime policy. His activities will include delivering public events on topics within the field of public policy in relation to crime and criminal justice, and engaging with our academic staff and our students, both MPhil, PhD, but also MSD students, who I think will particularly appreciate engaging with Max Hill's practical experience. Through the award of the fellowship, we honor his significant contributions to research and policy in a career that has taken him in and out of government, as well as into academic institutions. I'm delighted, Max, to have you here, and the floor is yours.
Well, thank you, Manuel. Good evening, everyone. And for the benefit of those who are joining online, I want to let you know that there's a gratifying number of people in the room, but there are more on one side than on the other side. So if I appear in any sense to be leaning to the right, I want to assure you that is not political. It is merely addressing the most people in the room. The journey to this evening has been an unlooked for pleasure May I start, please, with my thanks to the Institute of Criminology for inviting me to join the list of Rudzinovich Fellows. It's an honour and a privilege to be the latest in the line of fellows, which now stretches back 20 years. And so I did not hesitate to accept this kind offer. I need to tell you that my lecture notes for this evening consist of jottings made between 30,000 and 40,000 feet during a sequence of business flights from London to Budapest, New York, Washington over the past 8 weeks. And I'm therefore hoping that this process is not equivalent to thoughts from the early morning shower, which, as we all know, evaporate into nothing by the time the morning commute is over. However, I suppose you might say that as I wrote these lines whilst staring through a porthole at 40,000 feet, this is the epitome of blue sky thinking. And you are about to find out whether that is a good thing or not. Being my inaugural lecture at the start of what I sincerely hope will be a fruitful relationship with the Institute and with Cambridge over the next 2 years, the Viking DNA in me has decided to call this a smorgasbord of thoughts and ideas. Why? Because my aim this evening, I think, is simply to set out my stall with a view to attracting some interest from you that we might then take forward together. My professional life to date has been long, it has been varied, and so I hope that my time as the Rudzinovich Fellow will allow me to make a small contribution by being of some use to students at all levels, from PhD to masters and practice, and from academic study to public service practitioners. So whichever part of that spectrum you, with us tonight or online, occupy, I hope there will be something here that you can take away, even if you choose to discard, as you may, perhaps large parts of what I say. Now, before addressing my topics in earnest, I want to make one confession, or is it a disclaimer, or is it even a declaration of interest? I am, I'm afraid, a graduate lawyer from the other place, as Oxford people call Cambridge, and as Cambridge people call Oxford. My jurisprudence degree from St. Peter's College, Oxford, 1983-6, was the product, however, of my home tutor, Peter Hayward, himself an MA Cantab, as well as MA Oxon, no longer with us, but fondly remembered. My wife, Heather, read English at Teddy Hall, so we are indeed an Oxford couple. However, the salvation lies in the fact that my brother-in-law, Tim Coombs, is Professor of Engineering and Fellow of Magdalen, Cambridge, not Magdalen, Oxford. So I do claim a family toehold here, which I intend to build upon during my time with you. So much then for the introduction. The status of criminal justice policy in England and Wales is that it is in a state, I would say. I still retain dim memories, admittedly, of studying English legal history and constitutional law during my first year at Oxford a lifetime ago. But allow me a nod here, if I may, to our sponsor, Sir Leon Rudzinovich, author, as you will know better than I, of A History of English Criminal Law and its Administration from 1750, a powerful analysis of criminal justice policy. Rudzinovich was an important link in the chain of master jurists, those far better able than I to study the foundations of our law and how they sit within our society and our parliamentary democracy. I recall, in particular, trying to get to grips with R.W.M. Dias and his recognition of the interaction between law, morality, and society. Dias sought to balance judicial analysis of the law with the need for legal stability and therefore, I suppose, legal certainty. And in so describing and to that extent curtailing the role of the judges, Dyer stood as a bulwark against legal realists and realism, in which other scholars argued that what matters is what judges do in a practical sense, therefore bounded by less of the framework and principles described by Dyas. In our country, which still manages perfectly well without a constitution or a modern universal Bill of Rights, our Parliament is surely the fulcrum balancing these approaches. Because when the executive or government seeks to impose laws in order to govern, they must bring those laws before Parliament. And when the people exert pressure upon the government to enact specific laws, Parliament is the crucible in which the new product is tested. So what does this mean in relation to the causes of crime and reduction in crime through prevention and policy, the study of which is the raison d'etre of this institute? Well, to me, it means that the various bodies who bring forward criminal laws must be open to scrutiny in order to work out where they come from in relation to what Dyas says about this interaction between law, morality, and society, and whether after scrutiny they should be made good or not. Criminal justice policy is a term which is perhaps open to multiple definitions with either greater or lesser scope. For me, the creation of our laws may be the primary output of criminal justice policy, but that risks amounting to little or even nothing unless that policy embraces the utility of law through proper provision of resources for all of the professional bodies within what Sir Brian Leveson would call the criminal justice systems, note the plural, namely policing, prosecution, the courts, sentencing, prison, and probation. And we can perhaps agree a list of, I think, 5 places of origin when it comes to new criminal justice policy. Perhaps remembering my very brief introduction based upon Dyas and the need for law to come from a place of principles and rules, albeit that the law evolves because of its interaction with morality and society. So, of the 5, first, the government of the day via their manifesto commitments. Although, I have to say, recent history suggests that many such commitments are rolled out to the public in order to win votes on election day, only to wither away once a party has won power. Second, the Home Office, custodian of policy objectives across policing, crime prevention, immigration and security, including counterterrorism. Third, the Ministry of Justice, custodian itself in relation to courts, prisons, probation, sentencing policy, and rehabilitation. Fourth, the judges. Now, please don't panic at this point. I'm not going US Supreme Court on you. Our judges do not make the law, but they do interpret the laws enacted by Parliament, and to that extent, they do have an influence on policy. And fifthly, to me, it's very important to add campaigners, NGOs, pressure groups who seek to influence policy and to bring about changes in the law. In discussion with Manuel, whilst preparing these remarks, he pondered whether I should include journalism and the media here. I'm unsure, frankly, whether the undoubted power of investigative and campaigning journalism is actually part of this 5th category, or whether it stands alone as a 6th element. I leave you to ponder that. But I've been trying to think about this smorgasbord, as I'm calling it, And it occurs to me that many of these 5, or is it 6, influencers of criminal justice policy can be seen at work in what I'm going to call my top 10 of recent legislation. And this proves that there is no single route by which a new law comes into being. There may be a single mechanism, namely debate and ratification by Parliament, but that is a different thing to there being a single route. So let's spend a few minutes with the top 10, if I may. They're entirely subjectively chosen by me. They are therefore interesting to me, but I hope they are or will be to you. They are in no particular order. So starting at number 10, the current Home Secretary's plans for amendment to the Public Order Act 1986, by which the police would be empowered to restrict public demonstrations in the wake of the proscription of Palestine action. Is that law by and for the people, or is it law imposed upon the people? Well, I'm sure that you could argue it either way, and I could sit on the fence and do just that. But my view is this: if you proscribe in haste, I'm not at all sure that it can be right to then double down by taking steps that may be designed to enable nothing more than enforcement of that prescription order, but which have the effect of eroding a right of protest for any legitimate reason, which right, of course, has existed for centuries and which we lose at our peril, particularly, I would add, in the hands of future administrations who may make havoc with indiscriminate use of that new power, regardless of the restricted use for which it was initially intended. So that may be a controversial start to my top 10, but it firmly belongs in the list. And I'm going to move on, but I note that my first example would bear far longer and better analysis, not least, I may say, because of the foreign policy implications of prescription orders. Definitely in the example that I've just given, and there are others within the context of proscription, which is, of course, by its nature, a domestic executive order biting upon activity here, which may or may not be part of a wider whole, the remainder relating to international action rather than domestic activity. But let me move on at number 9. The Northern Ireland Troubles, brackets, Legacy and Reconciliation Act of 2023. Well, of course, to the genuine relief of all in Great Britain and Northern Ireland, the Troubles formally ended in 1998 with the Good Friday Agreement. In fact, related criminality did not end then. And I can testify to that because I was the junior member of the prosecution team at the trial of the so-called real RIRA bombers after their campaign of bombing in London and Manchester in 2001, 3 years after Good Friday. Equally important, though, is the fact that criminal atrocities committed before Good Friday have not all been answered by criminal prosecution. And as the Director of Public Prosecutions for 2018 to 2023, I was very conscious of the criminal investigations into mainland IRA crimes, which remained open, with police and legal teams still working hard to secure outcomes for victims and the bereaved. Nothing, I suggest, is more important than securing justice where serious crimes have been committed, no matter how long it takes. And I'm going to return to that theme of time. That is why we do not have a statute of limitations in England and Wales. That is why I was proud to take double jeopardy cases to the Court of Appeal during my time, securing justice 30 or even 50 years after the original crime. But this Northern Ireland Legacy Act has cut through all of that. I don't mind telling you that I argued against it. And I took that argument to colleagues and opposite numbers in the Northern Ireland office, but the law went through. Well, it did nothing good for the victims and bereaved in England, so far as I can see. Yes, it put a stop to legacy trials of former soldiers half a century after the event. I guess we've seen the last of them with verdicts in Belfast in the last 10 days. But what about the terrorists who have evaded justice for so long and who can now roam free? There's no justice there because the new law was a political decision forced into being by the Johnson government, far from being a new law by and for the people, it seems to me. Right, let's see if my number 8 is any less controversial. I fear not, I'm sorry to say, because it is the Assisted Dying Terminally Ill Adults Bill, currently in the House of Lords. I've been summoned to give evidence to the Lords Bill Committee next Wednesday morning, 5th of November. May I say here, for the benefit of international students, you may or may not come from one of the several dozen countries or indeed US states in which an assisted dying legislative model is already in existence, as opposed to England and Wales, where there is no such model. I have to declare an interest, of course, in the sense that it is the DPP of the day who, ever since the passage of the 1961 Suicide Act, bears the burden of deciding whether to prosecute surviving partners of those who choose to end their lives. And since cases such as Purdy and later Nicklinson, prosecution guidance drawn up by our present Prime Minister when he was the DPP mean that his successors have to agonize over these cases in the clear knowledge that even if a criminal charge is laid against, let's say, the lifelong spouse of the deceased, it is too late to prevent a death that occurred before any scrutiny or any investigation. So whilst I am not a campaigner for the current bill, I am clear, very clear, that the 1961 Act needs overhauling and Parliament needs to catch up with the times and to reflect British society in the 21st century rather than staying stuck in the past with legislation over 6 decades old. And therefore, I would claim that the Assisted Dying Bill, a private member's bill, of course, sponsored very ably by Kim Leadbeater MP, is an excellent example of people-made law rather than government-imposed law. And so I continue to watch and when asked to participate in its passage through Parliament with great interest. Let me move on to number 7. This is the Bribery Act of 2010. And this one is perhaps a good example of law in action because it demonstrates a starting point for developing criminal justice policy and then a journey onward from that point. 15 years ago, at the time of the 2010 Act, the principle of failure to prevent crime, as I'm sure you all know, was a rare concept in criminal justice and in a system where almost all crimes are those of commission, not omission. Just about the only outcrop prior to the 2010 Act was to be found in the Proceeds of Crime Act and money laundering regulations of the previous 1 to 2 decades. And that's where Parliament and government imported the principle of due diligence and criminal liability for failing to prevent money laundering with the associated reporting regime. Therefore, the creation of money laundering reporting officers, etc. I do recognise here that some of you might point to the Criminal Law Act 1967, which is somewhat earlier, where assisting criminal offenders might create a liability for doing little more than acquiescing in the acts of a principal offender. But that said, the extension of failure to prevent beyond money laundering and into bribery and corruption in 2010, I'd suggest was significant. By 2018, 7 years ago now, almost to this month, one of my first duties on becoming the Director of Public Prosecutions was to appear before the joint Post-Legislative Scrutiny Committee in the House of Lords. I gave evidence alongside the Director of the Serious Fraud Office. I argued then for greater application of the failure to prevent principle. In fact, I wanted such things as charging decisions to be delegable from the DPP to other prosecutors. I wanted to use powers of deferred prosecution agreements on behalf of the CPS for the first time. And I was one of many who participated in the Law Commission's work, which led us, bridging two of my top 10 here, to number 6, and that is the Economic Crime and Corporate Transparency Act of 2023, which actually gained royal assent in the week I left the Crown Prosecution Service, October 23. So this is the new corporate liability offences, which came into force last month, the beginning of September this year, extending that failure to prevent principle right across economic crime for the first time, as well as reforming the previous identification principle, which had proved problematic for prosecutors. So the new regime permitting now, for the first time, failures by any senior manager to bind the body corporate and make it susceptible to prosecution. The new act was also, worthy of note, a key plank of the former Conservative government's economic crime strategy. So you find it in version 2 of that published strategy. But it's come into effect, of course, under the Labour government, who appear keen to use it. So criminal justice policy can evolve, and it can also be handed off from one political party to another, even when they are divided on almost everything else. And so to number 5, let's go to another part of the legislative forest. Here we have the Overseas Operations, bracket, Service Personnel and Veterans, close bracket, Act of 2021. Rather like the Northern Ireland Legacy Act, which we've already considered, this was the former government's move, sponsored by Ben Wallace when he was Defence Secretary, to ensure that armed forces personnel do not face prosecution for alleged offences committed abroad unless this is done contemporaneously or within the first decade or even half decade after the crime. I see the connection between the two acts, of course, but I worry about where such policy aims are really taking us. And so here I draw your attention to the vexed issue of immunity from suit. Just as we are right, in my view, not to import the principle of limitation, even though most of Europe and many other parts of the world have a time limit on almost all crimes, so it troubles me that the Overseas Operations Act, in effect, grants immunity from suit to a class of British citizens, namely armed forces personnel who have served abroad. You may ask, well, is this important? Yes, I suggest it is, because it begs the question, where do we stop? once we've already started pulling at this thread. If soldiers, sailors, and aircrew are immune, well, why not police officers who have served abroad? Why not intelligence personnel embedded with armed forces abroad? Why not diplomats? Indeed, why not all staff who are employed on embassy or high commission platforms around the world? And if we're doing that, why do we prosecute police officers serving in this country if their own colleagues serving abroad are immune? Now, am I going too far? Well, it's for you to judge. I'm not so sure. I can tell you that I argued against the Overseas Operations Act, but again, to no avail. I have no personal interest in historic military prosecutions from overseas, and my jurisdiction as the DPP for England and Wales did not extend there anyway. But that's not the point. It is the unequal erosion of the principle that all are equal under the law. That is what troubles me. And it begs the question, is criminal justice policy being applied for the benefit of all, or to the advantage of some over others? And so to number 4, the Terrorism Act of 2006. And specifically, I'm going to take the example of Section 5, which is the offence of preparing for terrorism, which carries discretionary life imprisonment. I have to give a declaration of interest warning here. As a terrorism prosecutor for almost 20 years, starting, as I mentioned, with the real IRA, followed by Al-Qaeda, and then so-called Islamic State or Daesh, I used this Section 5 offence many times, indicting terrorists when they were caught in the act of instigating or preparing terrorism. And many convictions were secured, which I have no doubt kept more people safe from the atrocities which were in the course of preparation. So I actually have no quarrel with this new offence, or with many others approved by Parliament since what I suggest was the epoch-making Terrorism Act of 2000, which of course provided a definition of terrorism which remains a talisman, even though it is by no means above criticism. So what is my point then? My point is that the Terrorism Act 6 years later in 2006 was self-evidently the reaction to 7/7. It was the reaction to what happened on our streets and in our underground trains in July 2005. In other words, a raft of new offences passed in haste following that atrocity, on which I worked as a lawyer for many years, including representing the Metropolitan Police at the 7/7 inquests in 2009 and 2010. The point I'm making is that what might be called knee-jerk laws happen frequently, definitely in relation to terrorism, also in many other areas of criminal justice policy. Now, whilst that is understandable, acting on the "we have to do something" principle, it has led to a thicket of terrorism, of legislation in terrorism alone, where now, as a practitioner, you have to know upwards of half a dozen statutes in the last 2 decades alone. That's just for terrorism. Many commentators have contemplated actually rationalizing counter-terrorism law into a single, digestible and comprehensive bill. The terrorism equivalent, if you like, of the Criminal Justice Act 2003, an epoch-making redefinition exercise. But it's never happened in relation to terrorism, so we are left with this thicket, and it is not ideal. All right, let's turn to my top 3, although may I just repeat, all 10 are created equal, and it's a list, it's not a league table. Number 3, well, having just mentioned the vast and transformative Criminal Justice Act of 2003, with considerably less fanfare, Parliament passed another law in that same year, and that was the Female Genital Mutilation Act, also of 2003. I think that this is an excellent indication of how the law can change in a good way and how it can come to the aid of sections of our society who rarely reach public attention. Prior to 2003, our legislature, our parliament, called FGM female circumcision. You only have to look at the name of the 1985 Act to make that point, how wrong and behind the times that was. There is a world of difference between circumcision and FGM, which in my view should be recognized at last as a serious, life-changing physical assault on girls and women, a form of child abuse, nothing less. There are estimated to be 230 million women and girls alive today who have been subjected to FGM, and many of them live a life of continual and disabling pain. And victim survivors live in most of the countries of the world, including over 500,000 in the US, and something approaching that number here now in Britain. And before someone says, this is not a migrant issue, this is not something that is happening to them over there, it's happening to us over here. I mean, British citizens here and now. So this 2003 Act, in my view, was an about time law, about time that the legislature got it right. And yet, here's the point, the first successful criminal prosecution for FGM did not happen for another 16 years, until 2019. There's a declaration of interest here. I take no personal credit for it, but it actually was on my watch as the DPP that the first case was successfully delivered. The second took another 4 years. It came in 2023, and the third, which is in turn the first conviction of a man rather than a woman, was in 2024, only last year. So slow progress, but oh so necessary. I should add that I am now, since leaving the CPS, a proud patron of the UK's FGM charity, which is called the Vavengers. I urge you to look them up. There is so much more to report and to discuss on this subject. It represents criminal justice policy moving in the right direction. I think that's as much as I can say this evening. And let's move on for now. So number two is the offence of coercion and control, created in 2015, only 1 decade ago. If you're looking for a transformative effect through the effective use of policy and recognizing what is happening in this country behind closed doors, I suggest that this is it. Yes, of course, we have criminal offences, including grievous bodily harm, GBH, and ABH, assault occasioning actual bodily harm. And yes, we have assault, we have criminal damage, we have harassment. All of those are used in bringing criminal charges against domestic abusers. But when I was at the CPS so recently, domestic abuse was present in 20% of all criminal cases on the books. Let me put that into scale for you. The CPS is responsible for 300,000 to 400,000 cases a year, if you take the totals in the Magistrates' Court and the Crown Court combined. So this is huge. But domestic abuse and domestic violence in particular are the visible outcrops of what happens with chilling frequency. In other words, the subjugation of one person by another, normally the control and abuse of a woman by a man. But for all of the criminal justice tools that I've just listed, the criminal offences available prior to 1 decade ago, it was not until the formal recognition of coercion and control as a crime that prosecutors were able to do what I frequently encouraged at the CPS, namely to charge the abuser not merely for the violence, for the assaults, and for the broken windows, but to charge him for the entire toxic relationship. And that is what this new law enabled. And for the first time, it meant that judges could pass sentence on the entire abusive relationship, not merely the physical outcrops or the physical scars. And I say physical scars advisedly because that brings us finally to number one. And this is non-fatal strangulation or non-fatal suffocation. This became a crime during my time as the DPP. So in the last half decade. And at the CPS, we used it tens of thousands of times in the first few years. Why? Well, because what do you do if that toxic relationship that I've just described breaks out in the sense of the abuser using control and force to subjugate, the victim, but does it in such a way that virtually no physical mark is caused? Well, that, of course, is the hallmark of a non-fatal strangulation case. It's one of the worst forms of assault because it causes the victim to believe that they are going to die imminently from lack of oxygen, and yet it causes no marks. I have to say, I became aware of the terrifying prevalence of non-fatal strangulation when I heard about the pioneering work of Dr. Kath White at the Sexual Offences Referral Centre at St Mary's in Manchester. And once you know about it, you want to do something about it. And therefore, I will freely admit this is actually the closest that I came to campaigning for a change in the law during my time as the DPP. Of course, civil servants can't campaign. And even the most senior civil servants, of which the DPP is one, cannot present bills to Parliament in order to make new law. Why? Because only secretaries of state can do that alongside private members' bills, which I mentioned earlier. So officials like me never made law. We merely existed to put the law into effect, whatever that law might be. That's all fine, and that is quite correct. But I will admit that I pushed the envelope, shall we say, for non-fatal strangulation. I made it pretty clear that I would support that change, and the new law, entirely to the credit of Dr. White, not me, may I make that very clear, is, I think, a great example of criminal justice policy in action. And that is why it tops out my top 10, I think, quite nicely. So pausing there, I've never been an ologist. You are the ologists, I am not. I have been a practical lawyer, but nothing more. So it is for you to say whether any of my top 10 merit further exploration. For what it's worth, I think all 10 merit longer discussion. And all I can say is that if they light a spark with any student of the Institute or member of faculty, please let's talk. It is a very long time since I wrote an essay for a law degree, and I didn't do it very well 4 decades ago when I had no choice. But my hope is that there's something on the smorgasbord that I have laid before you that will sustain more detailed examination. And the good news for me is that this fellowship lasts for 2 whole years, so we have plenty of time. And for this evening, I don't want to detain you very much longer, but just a little more if I may, because alongside my top 10, there are, I think, a number of what I'm going to call thematic developments in criminal law and practice, which I want to share to you just in case nothing in the top 10 has hit the spot so far. So a few words about Brexit. How quickly can I do this? It's too large a subject to do justice to it here and now, of course. But it's well worth noting that the challenge of our departure from the EU, which was presented to law enforcement and to the law in general, was huge overnight. And it really was overnight, because we all remember, don't we, the brinkmanship of the final so-called deal in 2020. Overnight, we had to move as lawyers from one unilateral relationship between 27 member states to 27 bilateral relationships with our friends throughout the Union, which we had just left. The Trade and Cooperation Agreement TACA, as everyone calls it, which concentrated, perhaps understandably, more on food and fish than mutual legal cooperation. It left many gaps in our ability to pursue the three things that we need from Europe: evidence, suspects, and the proceeds of crime, i.e. cash. Those are the three things we need. So there was an initial scramble because we all had to fall back on the 1957 European Convention, particularly on extradition, whilst we waited for member states to enact domestic legislation in their parliaments, which would then reinvigorate and enable extradition as well as MLA, mutual legal assistance. Just as an example of that, there are more Polish citizens in our jails in this country than any other nationality apart from British citizens. It's not surprising. It's a product of the simple fact that there were more Poles living here before Brexit than any other European nation. So we ended up with a bilateral freeze on extradition cases between this country and Poland for a little more than 18 months, in fact, whilst we waited for the Warsaw government to patch up their legislation alongside TACA. It's a pretty extraordinary state of affairs, something which, to my mind, no politician involved in Brexit gave much, if any, thought to throughout that period from 2016 to 2020. So that's a big topic. Well, how about another one? COVID. Arguably the most prominent issue of my time as DPP, obviously alongside Brexit. For COVID, what we all know there is that emergency rules and temporary legislation were put in place. Now, I could actually spend time on the regulations for England and separately the regulations for Wales. They were different. They underpinned our communal lockdown experience. The police raids, the lockdown party fines, all of that seems like a bad dream now, doesn't it? Did it really happen? Well, I can tell you, trying to draw us into the legal context of this, that the use of the single justice procedure in bringing all of those cases before magistrates without any involvement by the CPS, that's the point about single justice procedure, was something of a disaster. Why? Because neither the police nor the single magistrate seemed to understand the technicalities of the regulations. And so the consequence was that hundreds, if not thousands, of these cases were brought in error. But there was one arguably positive outcome from this particular form of knee-jerk legislation. Another example of what I mentioned earlier. And the positive outcome played out in the case of Anne Sekulas, the US citizen who drove the wrong way down a road in Suffolk, not very far from where we are this evening. And of course, it cost the life of a teenage motorcyclist called Harry Dunn. One of the saddest cases in my entire time at the CPS. I still remember the anguish on the faces of Harry's mother, Charlotte, and the other members of her family as I tried to explain the difficulty that we were having in bringing Mrs. Sekulas to justice after she flew home to the US and returned to refused to come back. But the emergency COVID legislation came to the rescue for once because it permitted the use of remote hearings as never before. And I was pleased, and I have to say relieved, when Mrs. Justice Chima Grubb agreed to deal with Mrs. Sekulas, the judge sitting at the Old Bailey, Sekulas in her lawyer's office in Virginia or Washington, DC. And the remote sentencing hearing, which followed her guilty plea, brought to an end that most difficult case. And I hope it gave at least a measure of justice to all of Harry Dunn's family. I do just want to say something separately now about mental capacity as a separate freestanding criminal justice policy issue. The Mental Capacity Act featured in one of my top 10 for obvious reasons when we consider the rights of those who are terminally ill and who want to retain autonomy over the final phase of their life. But what about the high numbers of people who become entangled in the criminal justice system, many of them as defendants, where it's vital that we understand their capacity and their ability to participate in their own legal proceedings? As the DPP, I gave a lecture at the Howard League on this topic in 2019, which I think is still online. I concentrated then on one good development, namely the move away from what I'm going to call a medical model of capacity and towards a social model. To put that another way, the criminal justice system used to look at people through the lens of what they could not do, rather than what they could. So insanity, a term of art in criminal justice for centuries, a symbol of a system which distinguished between the bad, in other words, sane but criminal, and the mad, in other words, insane, and what are we going to do about that? And if a suspect or a defendant fell on the wrong side of what I would call this capacity or incapacity line, well, the justice system used to assume that they were disabled from almost any participation in their trial. Well, that can't be right. I know some now use the term other-abled rather than disabled. I actually rather like that. It places it in a positive context rather than a negative context. But except in very rare cases, people with capacity issues can still play their part, and they should be enabled to do so, whether you call that a social model or not. It is a way of flipping around for the positive. So, final roundup. It occurred to me just to look back across actually it's 38 years since I was called to the bar on the 24th of October, 1987. So what's that? 38 years in a week. Criminal justice policy has changed in so many ways over that time. I, of course, won't list all of the changes, but I am going to just take advantage of being the speaker this evening by recounting just 4 or 5 of the changes in each of the 4 phases of my career to date. So my selection is heavily influenced by those changes which have impacted directly on what I was doing at the time. Phase 1 was the longest, but I'm going to dwell on it only lightly, and that's the 30 years from 1987 to 2017, when I was in practice at the bar, 20 as a junior, 10 in silk. And what I've lit on here is marital rape. Marital rape is a criminal offence. Simple statement. It's extraordinary to me that this was not so in the early years of my career. It was not an offence. And I don't think I'm that old when I started in practice. So one wrong has been righted, but it is, I fear, emblematic of wide inequities between men and women which persist in our society, which of course is why 20% of the entire caseload of the CPS is flagged as domestic abuse related. Separately, suspended sentences. Just something very brief on that. They come and go with changes in the weather. There have been at least 3 comings and goings of the tide on just that issue across my time. From the perspective of the practical lawyer, which is what I'm here to give you, suspended sentences have actually caused relatively little concern. That's because it's enormously useful when you are hard-pressed in mitigation for your client to be able to say, I realise, Your Honour, that the court will place this offending beyond the custody line, but I seek to persuade you that there are reasons in this individual case to suspend. Very useful advocacy tool. However, to those engaged in criminal justice policy within the Ministry of Justice and elsewhere, suspended sentences, I think, are rather like a hugely overcrowded doctor's waiting room. Some of the patients in there will never cause a real problem, but others, flipping to the criminal language, will reoffend or in some other way break the conditions for their suspension, and when they do, A prison bed must be found when we all know there are none to be had. So a purist might argue that the courts actually should be deciding whether the person should be in or out. Don't place them in this hokey-cokey state of suspension. That's the conundrum. I live in hope that the Gork review, we await the government's answer to it, will introduce some clarity and some sense into the imprisonment issue. So that's phase one. Phase two for my career was short, but at least to me, extremely busy and challenging. I became the UK Independent Reviewer of Terrorism Legislation at the beginning of February 2017. That was exactly 3 weeks before the Westminster Bridge terrorist attack. And over the course of the next 5 months, we had London Bridge, Manchester Arena, Finsbury Park, and Parsons Green. In terms of combined international and domestic terrorism breaking through the otherwise, I do want to say, exceptional work of our intelligence services and police in thwarting intended attacks, those 5 months in 2017 were arguably the deadliest period to date. And the rise in online propaganda and the sheer amount of material now available to those who might self-radicalize, it's an ugly phrase, but we see it happening time and again, is part of this conundrum. The painfully slow process, which led to the estimable Online Safety Act, and the noble efforts now of Ofcom in finally taking down CSE, child sexual exploitation material online, is good, but the new powers are surely not enough to deal with the, quote, otherwise harmful material online. And there's plenty of that alongside the CSE. So we still have a real problem, and we struggle for the tools to defeat it. On this, I gave a speech at Swansea University as independent reviewer. I'm not sure 7 years later whether we have yet reached a better place. Just a word or two on deprivation of citizenship, because this is the other policy issue that I raise here. It still troubles me that we have a disinherited group of former British citizens, young and old, but particularly young, including children, many of them stuck in camps in northern Syria, and they're still there today. Well, all I say for now is that, yes, a country can wash its hands of one of its own citizens. That's what deprivation means. Although, I have to add, in some of the cases, the effect has been to create stateless persons, which is a breach of international humanitarian law, is it not? Nonetheless, that is what's been happening. But deprivation of a passport does nothing to reduce the harm that such people present or may in future present to us and our country in future. So blunt instruments may be said to have effect politically, but they store up problems for later. And then phase three were my 5 years as the DPP, 2018 to 23. I've already talked about some of the most significant issues during my time. I wanted to return just to say something about one of the biggest developments in criminal justice policy, namely the double jeopardy jurisdiction. So Part 10, Criminal Justice Act 2003. Whilst it may, I suppose, be simplistic to draw a line connecting no statute of limitations, no class immunity, and double jeopardy, to mention three of my themes, they all share something essential, which is that justice can sometimes be delayed, but it should not be denied. I watched a TV mini-series recently, I think it was called I Fought the Law, maybe you saw it. That was about the Dunlop case and the significant role that it played in changing the centuries-old rule that once a person has been tried and acquitted, they can never be tried again. Well, Dunlop, violent criminal, a murderer who boasted about his crime, he actually made a good test case for the new double jeopardy regime, although, of course, it was the killers of Stephen Lawrence and the failed private prosecution which created their acquittal, which looms large for me in the category of miscarriage had the law not permitted their retrial. Well, when I realized that the DPP has a personal jurisdiction here, namely the decision which is vested in the DPP by statute, whether firstly to grant the police a further investigation, which may of course include the rearrest and interview of a suspect post-acquittal, and then secondly, an application to the Court of Appeal to quash that acquittal. When I realized that those were tools that were on my desk, I was fascinated. And so much so that I decided to take one of those cases to the Court of Appeal myself as an advocate, because what better way to immerse yourself in close attention to the authorities, in which the Court of Appeal rigorously scrutinizes every prior decision each time one of these very rare applications come up. And so I have to say, with outstanding assistance from CPS lawyers and from the barrister trial team, which is not me, I appeared in the case of Gary Allen in 2020 before Lord Justice Fulford and a full Court of Appeal. And that was a precursor to Allen being finally convicted of a murder in 1997. And that case was then followed by another called McGrory. I did not argue this one personally in court, but that led to a conviction for a murder almost 50 years earlier. And I'm sure that I speak for the police and the prosecution teams on every double jeopardy case. I mean, there have only been a couple of dozen of them, but it is satisfying and it is right to achieve justice, even many years later. The counterpoint is what I've already said this evening. I disapprove of piecemeal limitations on the ability to seek justice wherever it is missing. But I shan't repeat what I've already said to you about immunity and limitation periods. And so finally to phase 4, which is ongoing. Since 2024, when I joined King & Spalding, which is a global US law firm with a significant presence in London, it is too early to draw together the strings of a practice that's still developing. But I spoke about the Corporate Transparency Act earlier and the new statutory regime, which forms a significant element actually of what we do in my practice group at the firm. I put alongside that forced labour and corporate supply chain due diligence. These are areas, and I suppose the point of interest, in which the criminal law and civil jurisdictions can actually come together. Both can play a part. That's a longer conversation. It's a learning curve I'm still on, I hope one of many. Thank you very much for listening.